We'll hear argument first this morning in Case 20-1410, Ruan versus United States, and the consolidated case. Mr. Robbins?
Thank you, Mr. Chief Justice, and may it please the Court. Dr. Shulu Ren's jury was instructed that it could convict him of federal narcotics offenses if he prescribed, quote, outside the usual course of professional medical practice. The 11th Circuit sustained that instruction precisely because it, quote, told the jury that good faith was a defense as long as the appellant's conduct also was in accordance with the standards of medical practice. In other words, good faith is a defense in the 11th Circuit only for doctors whose prescriptions are already lawful. No lawyer will stand up before the court this morning and defend either that instruction or the Court of Appeals rationale. And small wonder. Dr. Ren received little more than the instruction he would have gotten had this been a civil malpractice action in Alabama. So in our view, Dr. Ren's case must be remanded. And on remand, the 11th Circuit should either dismiss this prosecution outright for want of sufficient proof of Alabama substantive standards, or, at a minimum, order a new trial on all counts, this time governed by the correct scienter rule. And that rule, we submit, which largely tracks the law in the 1st, 7th, and 9th Circuits, is that a doctor may not be convicted under Section 841A1 unless the government proves that her prescriptions were made without a good faith medical purpose. The good faith medical purpose test makes the best sense of the statutory text, this court's case law. It also accords with the principles of federalism that are embedded in the statute itself, enables the jury to focus on the question of intent, as it always does in criminal cases, and affords an appropriate berth for doctors and patients to make the best choices for the individual care of what is often invisible and yet real and intractable pain. I'd be pleased to hear the court's questions at this time. Thank you.
Just a couple of sort of housekeeping questions. Could you explain to me exactly what the offense is here that the government is prosecuting?
The principal offense, Justice Thomas, is 21 U.S.C. 841A1, which is the principal narcotics distribution statute, and certain associated statutes that use the drug offense as part of the compound proof. So there's a racketeering charge, there's a money laundering charge.
Okay, so let's just stick with the first one. But there's nothing in there. There's an exception, right, to 841?
Yes, the except as authorized exception, correct.
Okay, so does the government have, when the government indicts, does it have to plead the exception?
No, I think under Section 885, it is not required to plead it. That is to say, the statute provides, Your Honor, that there is an obligation of the defense to put the question at issue. But once the defense does so, the circuits are unanimous, and I think correctly so, that it then falls to the government to prove the absence of good faith beyond a reasonable doubt, according to whatever the legal standard for good faith is.
So where does that come from, the legal standard that you're talking about in order to be registered, to be exempt from 841?
The legal standard, as I understand it, Your Honor, comes from the fact that the statute has an embedded exception for physicians.
Well, I understand that part. I'm sorry. Does it come from a statute or a regulation?
The obligation to prove good faith?
No, the standards for the exception in order to be registered, to not be covered, because 841 is a broad statute, right?
841 is a narcotics
I know,
felony.
and so it covers everybody. So if you just looked at that, a doctor would be covered.
Yeah, so we don't dispute that a doctor.
Now, but where does the standard, in order to comply with the exception, the authorization to write prescriptions, where does that standard come from?
The standard comes from, I suggest, Justice Thomas, the presumption of scienter, and the principle articulated in several of this court's cases we cite that says in substance that a scienter standard, which is presumed, and of course in this statute actually is express, knowingly
I
or
thought there were
intentionally.
standards that were set out by regulation on how a doctor was to conduct his or her affairs in writing these prescriptions.
The Controlled Substances Act largely leaves that to states and administrative boards. There aren't lots of explicit obligations built into the statute itself. On the other hand, the argument we are making today takes the knowingly and intentionally language in the statute and asks, to what elements does that apply? We contend that it applies to the except as authorized language in the statute. And so you begin with the presumption. You have the statute saying knowingly and intentionally, so you don't have to even read that in, as this court has done in other cases. And then the only question is, where does it apply? And the only element, Justice Thomas, the only element that could possibly separate innocent from wrongful conduct is the except as authorized language. Nothing else can possibly make sense.
The except
If
is
you're-
authorized. Go ahead.
What if you're driving along the highway, you're pulled over for speeding, and the officer tells you, look, it was 55 miles an hour, you get a ticket, and you say, oh no, I thought it was 70 miles per hour. You still get the ticket, right?
Of course.
What if you say you're pulled over, the officer says, you're speeding, it's 55, and you say, this is in the middle of Montana, I think it should be 70, and I was going under 70. You'd still get a ticket, right?
Yes, you would.
Well, how is that different if instead of speed limit, we're talking about what is understood, accepted to be in the course of medical practice and whatever the other thing was, in course of professional treatment or normal medical practice? You don't get, in other words, you don't get to say, okay, yeah, I realize the standard is, whatever, this many prescriptions a month or a year, but I think it should be this. That you don't get an instruction on that, do you?
Well, it depends. The answer is no. You don't get an instruction that says you can pick the rules you like. No. But the instruction that we are urging, which we think, by the way, follows from this court's scienter case law, doesn't create, I suggest, Mr. Chief Justice, it does not create some freestanding, choose your own medicine rule. What it does is it tells the jury, focus on intent, focus on purpose. You are free as a member of the jury to disbelieve the doctor's profession
Well, I
or
thought you
faith
told
medical purpose.
I thought you told me that he doesn't get to say, well, maybe again, but in the speeding example, he didn't work when he said, I thought it was 70 miles an hour when it was 55.
Well,
I believed in good faith. This is Montana. You can't see anything for 100 miles.
Yeah. Well, let me just say, I don't want to bury the lead. The fact is, this speeding is the classic case of a regulatory offense, the sort of situation in which scienter isn't even an issue. You don't get to defend the traffic violation based on your state of mind. But when you're talking about sending doctors, or anybody for that matter, to jail for mandatory minimums of decades in prison, this is not a regulatory offense. This is an offense as to which this court's case law on scienter applies with the most robust force it could. And so I don't I mean,
Counsel,
I take...
can we separate out two issues? Good faith, which goes to the extent of the knowledge, and the actual conduct that the government must prove. Now, I understood, as I read this, that A41A says the government must prove beyond a reasonable doubt that a doctor intentionally prescribed or distributed controlled substances, and you're saying doctors can do that. So the only way they can't do it is if they prescribe it other than for a legitimate medical purpose and not in the usual course of professional practice, correct?
Well, no,
No, you want to say something more, but I think that's what the statute says. The statute, by its words, says, well, putting in the exception, the government has to prove that he didn't do it for a medical purpose and in the normal course of business.
I think that's the very least they have to prove.
That's the least. Now the question becomes, who has the burden of proving or not good faith? Correct?
Well,
You say it's the government.
They say it's the government too. I mean, nobody...
Not good faith.
Oh no, I'm sorry, Your Honor. Nobody is going to tell you this morning that that burden somehow belongs to the defense. Everybody will concede. If you ask my friend Mr. Fagan, he will tell you that once the issue is put in play...
We will hear argument next in case 2016-41, Marietta Memorial Hospital Employee Health Benefit Plan versus DaVita Incorporated. Mr. Kulowitz.
Mr. Chief Justice, and may it please the court, for 4 decades, the Medicare Secondary Payer Act has been a coordination of benefits statute. It establishes that a group health plan must pay its benefits first during a 30-month coordination period when the plan and Medicare both cover an individual who must contend with end-stage renal disease. The plan must not take into account the Medicare entitlement or eligibility of an individual during that time or differentiate in the benefits that it provides between individuals with end-stage renal disease and other individuals covered by the plan on a basis that relates to that diagnosis. The Sixth Circuit has determined that there also is an implied mandate that dialysis providers occupy a specific position to be determined relative to providers who serve other vital health care needs of the 157 million American people who depend upon group health plans to defray the costs of their health care. When Congress requires a specific benefit or parity between benefits, it does so directly. It did not do that here. The Medicare Secondary Payer Act coordinates benefits. It does not prescribe them. The plan at issue in this case provides the same benefits uniformly to all participants and as primary payer during the 30-month coordination period. Respondents failed to state a claim on
We will hear argument this morning in case 21-147, Egbert versus Boulay. Ms. Harris?
Mr. Chief Justice, and may it please the court, this court should not expand Bivens for the first time in 40 years. First, Bivens extensions clash with modern precedent. Bivens interpreted federal courts' jurisdiction over federal questions as authorizing courts to fashion new damages actions. Decades of intervening cases reject that premise and remove any doctrinal basis for Bivens extensions. Second, this court has held that any reason to think Congress might doubt the efficacy or the necessity of a damages remedy bars new Bivens actions. Abbasi and Hernandez make respect for the separation of powers the key consideration. But the Constitution vests Congress alone with the power to create damages actions. Abbasi and Hernandez say courts must pause if the judiciary isn't well suited to assess the systemic costs and benefits of a new damages action. But courts are never equipped for such predictive empirical judgments. Abbasi and Hernandez also rule out Bivens extensions if Congress has extensively legislated in an area. But Congress has extensively legislated about federal officer liability without allowing individual damages actions. Third, at the very least, this court should not expand Bivens to First Amendment retaliation claims or to Fourth Amendment claims involving border security. Those claims raise yet further grounds for pause and would explode the universe of Bivens claims. For First Amendment retaliation claims, plaintiffs could portray virtually any governmental action as unconstitutional if taken for retaliatory reasons, creating especially amorphous Bivens liability. Further, allowing First and Fourth Amendment claims against agents involved in border security also implicates national security, as Hernandez recognized. And finally, there are many alternative means to protect these constitutional interests. I welcome the court's questions.
Well, Ms. Harris, when you have the Fourth Amendment claim in Bivens, is similar to the Fourth Amendment claim here. So why doesn't that foreclose your argument that that's excluded?
We respectfully disagree. The Fourth Amendment claim in Bivens is quite different from the claim here for a number of reasons. First of all, the class of defendants and the statutory mission of the officers is exceedingly different. The Federal Bureau of Narcotics mission is not the same in any respect as the statutory mandate under which Border Patrol officers are operating, and that is an important factor under Abbasi for a new context. And on top of that, we know, because Congress and the court have said so, that the Fourth Amendment applies differently in the border context. And that, I think, also goes to the Border Patrol functions. Border Patrol agents are in dangerous circumstances every day trying to interdict terrorists, smugglers, illegal entry and exit of foreign nationals crossing the border.
Couldn't you say something similar to that about police officers in the Fourth Amendment? I mean, it seems to be pretty much the same thing. But beyond that, though, if the court adopted your approach, what survives as far as Bivens claims go?
What survives is what we think the court recognized in Abbasi would survive. So the court said in Abbasi that it is not questioning the necessity or the stare decisis value of Bivens in the search and seizure context in which it arose. And I think the next paragraph of Abbasi illustrates the court was distinguishing between claims that would not be a new context for Bivens and claims that would be. So again, I think if you look at the facts of Bivens and the things that perhaps the DEA is doing today, that would absolutely survive. I don't think you have to resolve exactly what is or is not a new context, because this case, I think, is really about what happens when there is a Bivens extension on the table, when there is something that is absolutely a new context, and what factors should courts be considering in order to resolve that question.
Well, what is so different? This was a search of somebody on an unlawful search on private property. I mean, it was near the Canadian border. Okay, the guy was a border agent. Well, that doesn't seem to be particularly relevant to whether the other fellow was subject to an illegal search on his private property.
Well, I think there are two really important things that are missing from that sort of picture of it. One of which is that I think everyone agrees that Agent Egbert was involved in an immigration investigation, and that was the whole reason for being on Mr. Boulez's property, which again was a notorious site of smuggling and illegal entry and exit. So the fact that the Border Patrol agent was indeed exercising...
So they have more flexibility under the Fourth Amendment?